Good morning to all of you. Welcome to Legal Matters by Sai Babu Sankara. In this video, we are going to discuss the contempt action taken against a police officer for circumventing the provisions of Section 41A CRPC and not following the guidelines given in Arnesh Kumar versus State of Bihar 2014 judgment. By now, you might have understood the issue. So, whenever, if any offence falls within the below 7 years, then the police need not arrest the accused person. Their duty is to send a notice under Section 41A CRPC, and if he complies with the notice and if he says that he will be available and if the police officer is confident that he will attend the court, then there is no necessity for arresting him. If he defies the rules, yes, definitely you can arrest him. So this is what is envisaged in the very famous case of Arnesh Kumar versus State of Bihar 2014. Right? So Supreme Court has given directions in this line. So the police officers, the investigating officers particularly, they have to follow. If they don't follow, the action under contempt will take place. Same thing happened. So please remember, 2 judges bench of High Court of Allahabad High Court, by names Suneet Kumar and Syed Wise Mia, in case of INRI, so that means sumoto, INRI versus Shri Chandan Kumar, investigating officer, in contempt application number 5/2022, dated 18/8/2022, held that the police officer is guilty for not following the Section 41A CRPC guidelines or Arnesh Kumar case guidelines. Normally, every police officer is following the guidelines. But some people try to circumvent the law. This is important. Please remember these words. Some police officers are trying to circumvent the law. Of course, maybe to please the political bosses or maybe due to some other reason. Push should not be done. The court has identified the same and therefore action taken. Here, yes, he has followed 41A CRPC notice. Right. Now in this case, what has taken is, the offence is below 7 years. Right. So therefore, it would be suffice if a notice under Section 41A CRPC would have been issued to him and the arrest should be made in exceptional circumstances. Right. Here, the contemptor, that is Mr. Chandan Kumar, who is the officer in charge of the PS by name KANTH, KANTH, in Shahjahanpur district of UP, Shahjahanpur, maybe in UP, yes. So, he sent a notice under 41A CRPC to an accused who is a Muslim by community. Right. So, he came, he attended, and even then, this man showed the arrest of the particular individual, saying that the accused had willfully and deliberately denied to follow the conditions set out by the IO, and he is a Muslim and the communal rights may take place if he is not arrested. These are the reasons he recorded for arresting him. Right? So he has made an entry in the GD also. Now the High Court has gone through all the records. From the perusal of the records, it is very clear that there is no anticipation of the communal writings. The case was registered after pressure, after getting pressure from the higher officers. He did not register the case in this immediately. So normally, he would have been prejudiced by the accused's behavior of approaching the higher officers since the IO did not register the case. Maybe that may be one of the reasons. This is only my assumption. I don't know the fact. So whatever it is, he has sent a notice under 41A CRPC. But here he has clearly learned that he wanted to give a communal call, saying that the accused is a Muslim and he is apprehending communal rights if he is not arrested. But court said there is no such apprehension in the beginning. He did not at all register the case. The entries in the GD says that there is a delay in registering the FIR. He purposefully delayed the matter. Therefore, his contention that the apprehension of the communal rights is 100% not correct. Right? So please remember, it's nothing but circumventing or bypassing the Arnesh Kumar guidelines. this man has taken a casual approach of the Arnesh Kumar guidelines. Therefore, he wanted to circumvent the law. He said nobody will find fault with him. His approach is derogatory. The approach is not correct, no doubt. After that, on 4/8/2022, a contempt notice was given to him. So, in reply, yesterday, that is on 18/8, he has given the affidavit, filed an affidavit stating that he is a young officer, he has got family, he is the breadwinner of the sole family, his reputation will be at stake if he is punished. All these things he has written. But the court said that apology, actually, even though section 12 of the Contempt of the Courts Act says that if he apologizes, yes, you can consider it as a punishment. But still, High Court did not agree. Apology is not accepted because he wanted to circumvent the law. He knows the consequences of non-following the Arnesh Kumar guidelines, but still, he deliberately took a casual approach. Such people should not be let loose. If you are taken the apology in a good sense, it's not possible. Therefore, better not to take his apology into consideration. Therefore, he is given a sentence of 14 days jail, that is simple imprisonment, plus 1,000 rupees fine. Of course, you know, as per section 19 of the Contempt of the Courts Act 1971, it will be kept abeyance for 60 days, giving chance to him for appeal. I don't know what will happen in appeal. Anyway, the order is kept evidence. But here what you have to learn is, why should you go to that extent? Why do you want to circumvent the law? Normally, in certain circumstances, definitely will be forced. As police officers, you will be forced to circumvent the law. But that too in the correct way, not in the wrong way. If you do it, definitely you will face the wrath of the court, or you have to face the music from the court, and you have to face the contempt proceedings. And it is shameful rather, is it not? Going to jail. Of course, if the higher court is Allahabad High Court, then he has to go only before the divisional bench or the Supreme Court. If the Supreme Court is considered, it's okay. Otherwise, he has to suffer the so-called imprisonment for 14 days, and it will be a black mark in his career, is it not? So, police officers who see this video, please don't resort to such activities. Follow the law. Okay, if you are confident that he will not abide by the restrictions, make an entry in the GD, then take him to custody. That's all. Why do you try to circumvent the law in this manner? So, please read the judgment and enrich your legal knowledge. Thank you very much.